The matter before the court this morning is Kennebec 2553, the Maine State Chamber of Commerce and BIW versus the Department of Labor. I see counsel are present. I'm assuming ready to proceed. And I would ask that you identify yourselves by saying your names for the record. We are being streamed live on the web, both by audio and with video. Starting with the appellant, if you would identify yourself together with the party you represent.
Good morning, Your Honor. Sarah Murphy on behalf of the Maine State Chamber of Commerce and Bath Iron Works Corporation, here with my colleague Joshua Dunlap.
Thank you.
Attorney General on behalf of the State of Maine Department of Labor and Laura Fortman, the Commissioner.
Thank you. Are we okay? Let's do it now. We're going to do some technical adjustments on the microphone. Figure better to do it now than interrupt in the middle of everything.
Testing, testing.
I'm sure you did.
It's Murphy's rule of technology. If something goes wrong, it will go wrong at the worst possible time.
Testing. Okay.
At the moment, it sounds good. Hopefully, it'll stay that way. Attorney Murphy, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you, Your Honor. Good morning, Chief Justice Stanfield, Associate Justices. May it please the Court. I want to begin with what this case is not about. This is not about the enforceability or the validity of Maine's Paid Family Medical Leave Act as a whole. Instead, this is about whether the Department of Labor has the ability to alter the legislature's policy determinations through rulemaking. Now, the legislature determined that it needs to protect employees to take time away from work to care for themselves or their loved ones. And employers could satisfy their benefit obligations in one of two equal ways: the state PFML plan or a substantially equivalent private plan. The legislature decided that employers that offer a private PFML plan need not make payments to the state fund. Specifically, the legislature said in such circumstances, an employer, quote, is not required to remit premiums, end quote. DOL, through rulemaking, however, made the opposite policy determination. It adopted a rule requiring employers who offer a substitute private plan to make at least one non-refundable premium payment, half of which may be borne by employees. Now, DOL has been transparent regarding the reasoning for its choice. It wants to shore up the fiscal viability of the fund. But the legislature already determined that if there are solvency concerns with the fund, the remedy, according to the statute, is a delay in benefit payments, not duplicate payments by employers and employees opting to use a private plan. This appeal presents a straightforward question of statutory interpretation. The law says employers opting to use a private plan need not pay. The rule mandates the opposite. That should be the end of this case. Now, there is no ambiguity in the law. DOL argues that under the statute, no employer is entitled to an exemption until the agency processes the application. To the contrary, if an employer offers a substantially equivalent private plan by January 1st, 2026, the date the PFML benefits program goes into effect, it has offered a substantially equivalent private plan during all relevant periods. Even if there were some ambiguity in the law, the court must first look to traditional methods of statutory construction to discern legislative intent, including, relevant here, legislative history. The rule is contrary to the statements of the bill's own sponsors stated during the legislative session. Specifically, the bill's sponsors stated, quote, "For businesses with existing benefits, there would be no need to pay into the state fund under this law," end quote. The court owes no deference to the rule because it is unreasonable. It would impose double premium payments on the very employees that the PFML statute was designed to protect. And even if this court decided that the rule was not unreasonable, it should not blindly defer to the agency's interpretation. Chevron is an anachronism under Maine's separation of powers doctrine.
I see the green light is on. You just referenced the sponsor's comments during the hearings that I understood to be to the effect of, for businesses that already provide PFML programs, nothing would change for them. That is a forward-looking statement, and it implies that they already have them in place. My understanding is that during the one-year period after January 1st, 2025, there were no plans already in place that were sufficiently comparable to the rule, or at least they hadn't been approved at that point. So saying that they already provide the programs, no one was already providing one of these programs during that first year, or at least that first quarter period. Is that correct?
So DOL, under the rule, wanted to pre-certify approved plans through the Bureau of Insurance and through DOL. So as of the time of the statements, the sponsor's statements, that process, of course, had not yet taken place. However, if we are to assume, as DOL argues, that essentially no benefits programs existed, therefore all employers must pay, that would essentially render the sponsor's assurances to the legislature meaningless.
But the sponsor's statement was for businesses that already have one in place, that is what relieves them, but that contingency hasn't occurred at that point. It may be anticipated.
The existing benefits could have occurred, but DOL and BOI may not have pre-certified these plans through the approval process.
But the statute that you're focusing on that gives the exemption talks about an approved plan, not if you happen to already have some benefits in place. It's if you have an approved private plan. I mean, which really does imply that there's going to be process that needs to take place, that we're not recognizing plans at this point that are in effect as of the date of the effectiveness of the legislation.
Correct, Your Honor. But the process needs to be in place by January 1st, 2026 under 850B2. That is when the benefits program goes into effect.
That is when the private benefits go into effect as well as as the fund, correct?
That is when the entire benefits program
Okay.
goes into effect.
And
correct.
all of the employers who are not going to be obtaining a private plan have to pay for a year with no benefit to it before it actually begins.
Well, those benefits will be realized when claims start being made in May of 2026.
Maybe. There's employees that might leave in that meantime. There's employers that could go under. There's all sorts of things that could happen.
True. The record before this court, Your Honor, suggests that VIW's employees are paying into this fund now, and that there's nothing before the court to suggest that those employees will not maintain their status with VIW under the private plan. Mm-hmm. So in terms of reading all of these sections harmoniously, we've got the benefits program in 850F2, we have the exemption in 850F8, and we have the ability to tax the employers with costs under 850H7. If you are going to give intent to all of those sections, if you're going to read them all harmoniously together, as this court must, then the only reasonable reading is that the approval process needs to occur by January 1st, 2026.
What about 850H1, which clearly says application for approval of a private plan, an employer may apply to the department for approval to meet its obligations under this chapter?
Yes, Your
I mean,
Honor.
as the Chief suggested, That implies a process, doesn't it?
Yes, and that process can take place between January 1st, 2025 and January 1st, 2026. At the very least, Your Honor, even if that's not this court's interpretation, that there should not be a year of process, which is reasonable for the legislature to allow a year of process for that to occur. At the very least, also 850F2 states that these premium payments need to be remitted quarterly. DOL, however, manipulated the timing provisions of the rule to make it impossible for employers to even apply for that exemption.
Do I understand the rule to mean that if BIW or any other employer submits a request, an application for an approved plan in April or after the April 1st deadline, and it's approved, that employers do not have to start providing benefits and do not have to pay additional premiums until they actually start providing the benefits?
They do need to provide benefits under their substantially equivalent private plan starting when the benefit plan comes into effect on January 1st, 2026.
But they could go for 5 months, 9 months, some period of time without paying premiums and without offering benefits under the plan, and without paying premiums to their private insurer?
So the premium payments for the state plan there's a lead-up period, so there's sufficient allocation in the fund so that when premium payments need to be distributed as benefits come May of 2026, there are sufficient amounts in the fund to pay out those premiums for those in the state plan. For private employers and employees under private plans, the private plans don't need the lead-up period because they're private insurers who have the ability to be more efficient in the way that they pay out benefits. So they are going to collect premiums once those contracts go into place on January 1st, 2026.
But to Justice Douglas's point, what he's suggesting is that if you have an approved private plan, even under the existing rules, an employer like BIW will pay 1 quarter into the fund and then not have to pay anything and not offer benefits until January 1st.
So no one is going to offer benefits until...
Understood. So isn't that a positive for BMW and other employers who don't have to offer the private plans until January 1st, and they don't have to pay premiums for arguably 3/4 of the year of 2025?
So the employees that are paying into the state plan are going to see those benefits if and when they make a claim under the state plan. For employees under the private plan who are remitting those same premiums for the first quarter of 2025, they will never see those premium payments through any claims process starting in 2026. So they do not have any...
Most employees won't see them, presumably. I mean, we're assuming, that's like an assumption that every employee is going to make a claim.
Correct. I'm not assuming that every employee is going to make a claim under the program. I'm just saying that the availability to make a claim under the program exists for the state program, and those premium payments are made for the year before the program goes into effect. For the employers who are under a private plan, although they have made those premium payments to the state plan, they will not receive any benefits out of that state plan come May of 2026.
Could the legislature simply have said, we're going to make a special assessment, monetary assessment on all employers, regardless of when benefits start getting paid? Couldn't they do that?
Arguably, they could have, Your Honor. They didn't.
Isn't that essentially what they did?
No, Your Honor. They specifically made an exemption for private insurance plans under F8, saying that those in approved private plans under F8 do not need to remit premiums.
But it does...
Approved, yes, an approved private plan.
Yes, and so I understand that there is a process for verification, and I'm not suggesting there's not. I'm not suggesting that DOL does not need to go through the process of verifying that the plan complies for substantial equivalence under H1, that it complies with the additional requirements under H2, or that it needs to maintain the exemption under 850H3. I'm just saying that that process can occur by January 1st, 2026 to give effect to all of the provisions in 850F, H, and B.
So boiling your argument down to its essence, we're really talking about the first quarter and the money that was paid in during that time, assuming everybody's going to get approved as of April 1st, right?
Yes.
So that's what we're talking about. Is it your position that under the current status of the rules and the statute that if and when your clients get their approval on April 1st that says they don't have to pay in premiums, that should operate retroactively to that first quarter when they did pay in those premiums?
I think that if you don't operate it retroactively to allow a refund of those premiums, then DOL's interpretation of the statute is essentially rendering 850F8 as an illusory exemption for at least the quarter one of 2025, and also rendering 850B, the effective date of the benefit program, illusory as well.
Thank you.
Thank you, Your Honor.
Attorney Makarowski.
Thank you, Your Honor. First, if I could begin by clarifying the dates. Premiums begin January 1st, 2025. Benefits begin May 1st, 2026. There is a line in 850B that the program begins January 1st, 2026. Actually, nothing really happens on January 1st, 2026. Quite frankly, I think that's a Scribner's error. The program's in place now, January 1st, 2025. The statute says that an employer with an approved private plan is not required to remit premiums. The legislature directed the department to finalize its rule by January 1st, 2025, and that rule would state, among other things, what a substantially equivalent private plan is. So it was impossible to know what would render a private plan acceptable to the department until the rule was finalized. As the stipulated facts set forth, the insurance industry knew that. The insurance industry told the department, once you get your rule done, it's going to take us a couple months to have approved private plans. About a dozen states have PFML statutes, but they're all different. They have different insurance policies in all of them. There is not a private market. The department reasonably anticipated there would not be a private market for private plans until April 1st, 2025. Those 3 months, that quarter, because the premiums are submitted quarterly, that was the smallest unit of time that was feasible to the department in order to then start approving private plans as of the beginning of the second quarter. As Your Honor has pointed out, in the meantime, the statute also says, it says employers and employees begin paying premiums January 1st, 2025, period. There's no exemption, except, it doesn't say, except employers who might someday have a private plan exemption. Also, just two other points that I want to make is employees and employers who are in a private plan substitution, they're only exempted from premiums. They're still covered by the PFML statute, and they still have all the rights and all the responsibilities of that. For example, there's a non-retaliation clause. That means, and there is no private right of action to enforce that. The Maine Department of Labor enforces the non-retaliation, including for employers that have private plan exemptions.
Given that the green light is on, can I go back to something that you said earlier? You said a Scrivener's error is Section 850B, where it says that the Paid Family and Medical Leave Benefits Program is established effective January 1, 2026. You think that's a Scrivener's error?
I do, because that date makes no sense. January 1st, 2025 is when premiums begin.
Correct.
That's the beginning of the program. The program's beginning now. And that's a specific date, which is in the statute more than once. And benefits begin May 1st, 2026. Benefits do not begin January 1st, 2025.
By statute?
By statute.
Okay.
It's a pretty major error. But I see support for that in Section 850E sub 6, which says that beginning October 1st, 2026, and annually thereafter, the administrator shall publish a report providing information for the previous fiscal year, which obviously could not be the case unless the program had begun before January 1st, 2026.
Correct.
But the record suggests that a number of applicants for alternate plans filed their proposals by February, so it sounds as though the April date, at least for those employers, has delayed their ability to obtain approval.
What happened by February is that insurance companies submitted their proposed plans for certifications.
Okay.
There's essentially a two-step process. First, the insurance companies submit their plans for certification, which the Bureau of Insurance looks at, and then the Department of Labor. And then, so those were accepted before April 1st, so that on April 1st, there were then 20 or so private plans that were certified, and then the department was ready to go and to begin accepting applications.
But a self-insured employer would not have to go that route, right?
That's correct, but it would also be April 1st, 2026 for self-insured employers also.
2026?
I'm sorry, 2025. April 1st, 2025. And one other thing, even though insurance companies started submitting in February, I mean, that was not a fact known at the time that the department wrote the rule. When the department wrote the rule, it reasonably anticipated, based on what the insurance industry said, that it would take several months. The department was quite surprised that then in February they started rolling in. But the rule was already written and finalized based upon an anticipation that it was going to take the insurance industry longer than that.
So at the time they wrote the rule, they knew that they were preparing a scorecard, if you will, that had been developed by the Board of Labor, the Insurance Board, as well as DOL, as to what the insurance companies were going to need to put in to have a compliant private plan.
Right, and what they needed to put in was in the rule. So that was not finalized until the rule was finalized.
What I'm suggesting is that, seeing as the insurance companies knew what was in the rule and managed to get policies out by February, imposing an April 1st delay date before anyone could apply seems to be a bit arbitrary.
It was not arbitrary. It's based upon the February date, the fact that applications came in from insurers for their plans to be improved was not anticipated that that would be February, based on what they said. At the time of rulemaking, what was anticipated was several months. And then the other reason why it's not arbitrary is because the statute says that wage reports and premiums are submitted quarterly. So for administrative feasibility, the department wanted the breakup to be by quarter and not in the middle of a quarter, because that causes all sorts of administrative issues. So the earliest date that the department was reasonably could anticipate that private plans would be in place and there would be a robust.
I think I hear the appellant saying, yeah, okay, we get that there was a built-in delay there. But if I understand their argument correctly, they're saying, all right, well, we couldn't get this as of January 1st. We couldn't get the approval as of January 1st, 2025. So, yeah, maybe it had to be later. We're okay with that. But I think the crux of their concern is that, and I think the appellants or the amici said, to credit the department, they said this opening period with non-refundable payments does front-load the process. And that the department acknowledges, yes, that's occurring, and that was intended. Am I correct on that?
Yes, it front loads the process because those employers and employees are still covered by the plan, except for premiums. As I said, audits, the non-retaliation, there's no private right of action.
Right. I think we're on the same page on that. But I think the concern is, when they have an approved plan after April 1st, the statute says they're not required to remit premiums under the section to the fund, period. And that means that if it's as global as it sounds, that's a pretty broad statement there, that those payments that had been made previously should either be refunded or credited or somehow nullified because they, in fact, did obtain the approval. And one, I don't remember if it was the appellants or the amicus, said it really was just a blatant, and I'm quoting their quote, a money grab to get some large employers to front load the financial process going forward. And they conclude or they argue is inconsistent with the statute. Your response?
First of all, the statute anticipates that the entire program needs to be front-loaded. We call it the lead-up period. It needs to be front-loaded. It's the reality of the situation. And there's a 16-month front load. The employers who can be approved and pay as little as 3 months, so 13 months are free. And the other thing is that the rule says that the exemption is an employer with an approved private plan. The word refund is not in the statute. The word and the concept retroactive is not in the statute. The wording of an employer with an approved plan is not required to remit premiums. The grammar of that sentence, nothing suggests that they're then entitled to a retroactive refund back.
Are you
to
essentially
January
reading
1st.
850F8 to say an employer with an approved private plan in place?
Yes, Your Honor.
And that just sort of takes, if you read it that way, that you're saying that takes care of all of the arguments.
Yes, Your Honor.
But the statute doesn't expressly say that. It doesn't create that. It's a very broad statement. If
Yeah.
they said, if an employer has a plan in place, then they don't have to make any premium payments after that point, then we probably wouldn't be here today. But it doesn't say that.
But your suggestion would be that they don't have an approved private plan unless it's actually doing something.
Has the department approved any plans today?
Yes, yes, the department has approved many, many plans. Would you like numbers? I mean, now there are, the department has approved that only 3% of employers in the state have submitted applications for private plans have been approved. Those 3% of employers represent about 30% of employees. So large employers have submitted this.
And just to be clear, those plans have been approved.
Have been approved.
And so those employers are no longer paying premiums into the fund.
BIW and other employers with an approved private plan are no longer paying premiums into the fund as of the second quarter.
We're just talking about that first quarter
We are-
lead-in
Yes.
or front load, whatever you want to call it.
Correct.
The argument that the appellants are making is that the April 1st start date for submitting alternate plan proposals artificially delays the opportunity to obtain approval. In other words, and the state's position is, well, they probably couldn't have submitted their plan much before that date anyway because of the rules didn't come out and the criteria didn't come out. But even so, isn't the April 1st date an artificially imposed delay on an employer's ability to submit a proposal and obtain approval?
It is not an artificially delayed date. First, because as Your Honor just said, the rule had to be in place as to what is a substantially equivalent plan, and the insurance industry had told the department, this is in the record as a stipulated fact, the insurance industry had told the department that it would take several months once the rule was final for there to be actual private plans. So that way it's not artificial. And why April 1st was selected is because that was the beginning of then the next quarter, and that was to minimize the time that employers seeking private plan exemptions.
But what's the need for a date anyway? Why does there have to be a start date for submitting proposals? Why couldn't it be any time after January 1?
That was for, that was an administrative efficiency, because the department did not want to be put in the position that there were applications for private plan substitutions and the commercial private plan had not been approved. They didn't want the situation that then private plan applications would sit for weeks or months, with employers then being quite upset at the department for not approving private plans.
Following up on Justice Horton's question, though, looking at the comments, or at least response to the comments, one of the comments that was received was that there was a concern that the Department of Labor was not going to be refunding premiums that were paid prior to having a private plan approved. The department's response was that no, it's not going to be providing refunds to employers for premiums remitted prior to the approval of the private plan substitution. But then it goes on to say, the department's response says, it notes that the approval or denial of private plan will take place before premiums are due for that quarter. So how does that fit into what you've just described?
So that BIW, for instance, submitted its application in the middle of April. The quarter started April 1st, so they were not required to submit premiums for the entire second quarter. So what the rule sought to do was to keep all the quarters intact so that quarters weren't being broken up.
Thank you, counsel.
So the suggestion seems to be that since BIW did not submit its application on April 1, but later in April, no harm, no foul, there was the delay in the application process didn't cause BIW any particular harm.
So I would take issue with that, Your Honor. The April 1st deadline is, again, so the department is basically saying that, yes, the statute suggests that it puts the word approved in place prior to being exempt under F8. But DOL prohibited the possibility of having the exemption in the quarter 1 of 2025 by saying that there were no applications that were going to be allowed to be submitted in that quarter. Now, DOL is arguing essentially that that was for administrative feasibility issues, administrative convenience, administrative efficiencies. But if there's a question about how long something's going to take or preventing a logjam, one would assume that DOL would say, as soon as the insurance companies have the programs, as soon as they're certified, as soon as DOL's checklist is verified, then have at it. You're permitted to apply for your exemption as soon as you possibly can.
Except that that's not what it says. I mean, under 850F8, it seems to me, how can an employer be an employer with an approved private plan unless it's both been approved, it's been approved by the Insurance Bureau, it's been approved by the DOL, and it's in effect. I mean, you don't have a plan if it's not in effect.
But DOL made it impossible for employers to give meaning to that section of the statute in quarter 1 of 2025 by saying we're not accepting applications.
But you're not required to have it in effect until 2026.
But the employers were eager to get these exemptions in place in quarter 1 because F2, as
they were eager to get the exemptions in place, but were they eager to have the plan actually in effect in the first quarter of 2025 when they weren't required to do so until sometime in 2026?
The plans are in effect under both the state plan and the private plan starting in 2026.
All right, benefits available, let's put it that way.
Benefits are not going to be paid out in either plan until 2026.
Right.
But DOL manipulated the timing provisions under the rule to say we're going to render F8 surplusage for at least quarter 1 of 2025, and we're not going to allow employers to apply for the exemption during that time period because we want to shore up the fiscal viability of the fund. And the legislature was very clear that if there are solvency concerns with the fund, the remedy, according to the statute, is a delay in benefit payments under 840.
And your argument, boiling down to its essence, is that the manipulation, as you're saying here, was not something that was authorized by the statute, that they acted beyond the scope of their authority under the statute.
Correct. I think it's directly contrary to the statute, Your Honor.
Was it contrary to the statute's concern about the solvency of the fund that's going to be available for the state plan?
if there are solvency concerns with the fund, and we don't know that as of right now, there will be a viability report done in February of 2026, and then benefits can start being paid out in May of 2026. If there are solvency concerns at that time, the legislature has stated unequivocally the remedy is a delay in benefit payments, not duplicative payments by employees and employers opting to use a private plan.
Thank you, counsel.
Thank you, Your Honor.
Thank you, counsel, for your argument here this morning. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. With that, we'll be in recess this morning.